Good evening to one and all present here. This is Ruksha Ahmed, Executive Member at Legal Vidya, and I am delighted to welcome you all to today's free live masterclass on property and real estate laws, a practical insight. About Legal Vidya, established in 2021, Legal Vidya is a pioneering online edtech platform committed to nurturing legal education. We provide diverse opportunities such as internships, webinars, workshops, and courses, catering to the varied learning needs of law students and professionals. We also offer a platform for article publications, fostering a vibrant community of knowledge sharing and meaningful legal discourse. About the webinar, this session is specially designed for law students, judicial aspirants, and legal professionals seeking clarity on the legal framework governing property and real estate in India. The discussion will cover essential aspects like transfer of property, registration, stamp duty, tenancy issues, and dispute resolution, alongside the regulatory framework under RER. Participants will also gain practical insights on property transactions, emerging challenges in the real estate sector, and judicial trends shaping this field. The session promises to bridge theoretical knowledge with real-world applicability, making it equally valuable for students, aspiring litigators, and working professionals. About the speaker, we are honored to have with us Advocate Govind Bali, Managing Partner at Fast Track Legal Solutions LLP and a practicing advocate based in New Delhi. With wide-ranging expertise in civil, criminal, corporate, and regulatory litigation, he has made a strong mark in real estate law, RERA disputes, and commercial litigation. He has represented clients before high courts, and his sharp legal reasoning and effective courtroom strategies is what he is known for. He is also the founder of LetStartup.in, a legal and business platform dedicated to startups, where he advises entrepreneurs on compliance, dispute resolution, and regulatory matters. As a speaker and thought leader, he is regularly invited to seminars and training sessions, particularly on RERA, consumer protection, and startup law. Today, he will provide us with both conceptual clarity and practical strategies for navigating property and real estate laws in India. The recording of today's session will be shared with all registered participants. I encourage everyone to engage actively and make the most of this learning opportunity. Now, without further ado, I invite Advocate Govind Bali sir to kindly take over the session and guide us to today's topic.
Hi everyone. I hope I'm audible.
Yes, sir.
Sorry for a bit delay, but today's session, as the title says, is about property laws. Property laws are one of the largest and the biggest wealth class in India. When I say it is the biggest wealth class in India, what I mean to say is that there is no better investment than property in India, but there is also no more unsafe investment in India than property. So when we talk about property law at large, property law is considered as civil law. But there are certain ways by which it has also been considered as part of it can also go into the criminal side of it. So now what we are going to talk about is that what is property law? Why is it considered as an important part? Why do we need property laws? What is RERA? Why was RERA brought in? What is the ideal way of dealing with the laws and how do we uh, deal with it. Now, one of the interesting facts is that more than 60% to 65% of civil litigations in India are related to property disputes. And when I say that, I say it with a lot of authority that 65% is a big number. Some years back, RERA did not exist. RERA is the Real Estate Authority and Real Estate Regulatory Act. Now, basically, what we are going to start with is we're going to start with why property law matters, what is the idea of property law, and how do we deal with it. Now, basically, majority of the family disputes also in India are dealing with property laws. Now, when we talk about these disputes, whenever there is a division of property, wherever a will exists, or whenever there is a transaction happening, it is the property law that takes place. And that property law in itself is dealing with the very idea of the webinar today. Now, property law basically forms the backbone of wealth management in India, whether you're buying a flat, inheriting an ancestral land, or leasing commercial spaces for your startup, you're reading and dealing with property law. Now, as lawyers and law students, what is our role and dealing with the very idea of property law? What we need to understand is that unfortunately, ignorance of property law is widespread. When I say that, people buy properties without proper research, people buy properties without being known for the very idea that why are they buying that property, what kind of property is it a joint property, it is an individual ownership property, whether it is a lease whole property, whether it is a freehold property. This is what we're gonna talk about now. Now, basically, the ignorance of property law, which is widespread, people rely on brokers, builders, or family advice and end up trapped in legal quickstands. Today, let us start with the foundation. Now, what are the types of properties and ownerships? There are basically three types of ownerships that I deal with and I want to talk about. One is freehold, leasehold, and then joint hold or individual ownership. Now, what is a freehold property? जब हम freehold नाम सुनते हैं, when we understand the very word freehold, it means that the complete ownership is transferable and inheritable. When we talk about leasehold, that means that is limited time ownership. It is very common in places like Chandigarh, Delhi, wherein Noida also, wherein the property is leased to somebody for a certain period of time. For example, DDA flats are leased for a period of 99 years. Now, basically, if you buy a DDA flat, it is a leasehold flat. That means technically you own the property for 99 years. But if you buy a freehold property, you can sell or mortgage it without any restrictions. So basically, when you buy a freehold property, you can take a loan on it, you can sell it without the NOC of DDA or the authority which is leasing it. Further, you can also basically I deal with the very system in which the property can be developed in whatever way you want to do it. Whereas in DDA flats or in the authority flats, which are on leasehold, the property cannot be modified as per your own will. Now, there are some basic acts we're going to talk about. Now, what are the acts that are basically dealing with property laws in India? Now, basically, there are four acts that I want to deal with. That I deal with: Transfer of Property Act, Registration Act, that is the Registration Act of 1908, the Indian Succession Act of 1925, and the Hindu Succession Act of 1956, which was further amended in 2005. Now, when we talk about the judicial exams, Transfer of Property Act has got questions coming from there. When we talk about the Succession Act, there are a lot of questions coming in from there. And Succession Act is a very important part of the whole procedure. Now, what are the essential documents under these acts and why are these acts important? These acts govern how property can be sold, gifted, mortgaged, or inherited. If you know at least these names, you can ask the right questions before signing any paper. Now, basically, we need to understand is that under these acts, what comes in. Now, we must have heard these words: sale deed, gift deed, will, power of attorney. What we need to understand is that sale deed is what and how is sale deed important? Why is sale deed important? And where do we get, why do we need a sale deed? Now, basically, what we need to understand is that when we talk about transfer of full sale deed is basically a proof of ownership. When is sale deed done? Sale deed is done when a actual regular sale takes place, and that sale deed is registered. And then after that, your property belongs to you at large. Now, basically, second question is what is a gift deed? Now, to transfer a property, it is not always important that you want to do a sale deed to someone. If you want to gift your particular property to somebody, you need a gift deed. But people think that gift deed can be done without registration. A non-registered gift deed is not very legally viable document. When I say it is not a legally viable document, it clearly means that that document is not going to be legally sound and can be challenged easily. What is a will? Now, will basically is a document in which you transfer your own property to somebody by the way of a will or wasiat, as it is commonly called as in India. But the transfer by a will takes place after your death. It does not happen before your death, neither it happens at the time you are alive, nor it happens before the period of your death. So basically, uh, the very idea of will only comes into place after the death takes place. Now, there is also one very much uh, used in a very wrong way, a document called power of attorney. But it is very useful. There is no doubt. A power of attorney gives somebody else the authority on your behalf to deal with the document, it to deal with your property. But generally, it is very badly misused. When I say it is misused, those of you who are raising your hands, really take the questions at the end, please. I once handled a case where a son sold ancestral property using a forged GPA. Now, GPA basically means a journal power of attorney. The court not only voided the sale, but also sent the buyer into years of litigation. Never rely on a GPA alone. You need to be very sure that you have got the whole sequence of documents. Now, the sequence of documents could be the chain of the property, that who was the first buyer, how did the chain go on, who was the second buyer, third buyer, and how did the property go from one person to the last person. Now, what we need to understand is that how do these properties actually uh, happen to take place. Now, what we need to understand is what are the basic disputes that take place. This is going to be my second part. Uh, that how do property disputes take place? Why should we basically dive into them? Now we understand the basics of what property law is, but what we need to understand is property disputes are basically the bread and butter of Indian courts and Indian lawyers. If you walk into any civil courtroom in Delhi, Mumbai, or even a district court in Punjab, 9 out of 10 cases will involve land, house, or inheritance. The reason is, if I ask you why, my answer would be because property is not just money. Property is it's about izzat, it's about legacy, and unfortunately, it's also a magnet for fraud. Now, in this section, I'll be taking you through four big categories of disputes: family feuds, frauds, tenancy nightmares, and NRI property traps. Each of this is a minefield, and I'll show you how to avoid stepping on one of these. Now, basically, family dispute, blood is thicker than water is a very common word that I use until property comes in. Now, family disputes in property is disputes between siblings after the death of their parents, daughters' rights after 2005, inheritance and succession confusion. In state, basically. Sorry, I said inheritance. It is in state succession confusion. Now, what is in state succession confusion? Is basically when somebody dies without a will. Therein it comes as in state property succession confusion. Now, let's start at home. Families do not think blood relations mean trust, but in India, property turns brothers into plaintiffs and sisters into defendants. A classic example is ancestral house in Old Delhi, father dies without a will. Son says this is ours, daughter says we have equal rights. Until 2005, courts often sided with sons. But after the Succession Amendment Act 2005, daughters became equal co-partners. Now, co-partner basically means a person who's got right over the property. Now, equal rights, even if they were married, even if the father had passed earlier, the Supreme Court in Vinita Sharma versus Rakesh Sharma 2020 settled it. Daughters have the same rights as sons, as in ancestral properties. That's it. That is not just a full stop after that statement. It was a word and a precedent that is being used widely in the Indian courts today. Now, moral of the story is very simple. You do not assume family understandings work. You need to make a registered partition deed or will, because otherwise you are just reserving seats in court for your children and paying more than the property amount to your lawyer. What we need to understand is that why partition suits have become such a big issue. During the family time, greed is not there. When we are young, brothers do not think of fighting with each other on trivial issues like property or on the division of property. But as soon as the time passes away, and as soon as the idea of basically the very idea of life changes, people start thinking that why should he get the property? I was the one taking care of my parents. He was not the one taking care of his parents. In case of daughters, generally brothers think that it was basically during the marriage of the daughter or a sister, everything was given to her by the parents. Now, the very question is, why did the idea or the very judgment of equal rights come in? The very idea of equal rights come in because there are times when daughters had been fighting for the very rights of property in the Indian system. And as per the Indian system, we did not have the right to give daughters did not have the right to claim properties in their ancestral property or father's property also. So basically, these judgments, whether it is Vanita Sharma versus Rakesh Sharma or other judgments that came in 2005, the principle is very clear that daughters have equal right in inheritance of the property. Now, fraud and misuse, the favorite sport of builders and middlemen, that is where RERA comes in. Now, basically, a lot of people are misusing the very trust that people put in them. Fraudsters are thriving in the property because it's high value and low awareness. The most common trick, selling the flat to two or more buyers. I know most of you must have heard that that plot belonged to him, but somebody else is also a partner to it or has been brought into it. Now, in one of my cases, a builder sold a 3 BHK flat in Noida to a client. 6 months later, my client discovered another family living there, claiming they also have a registered sale deed. Who wins? The one who registered first? The other ends up in court for years fighting with the builder. That very builder, who is basically not even aware of the very fact that he's done a wrong. And that builder is not there in the courtroom because he's selling these many more same flats in the same building to many more people, which is causing a lot of property disputes at large. Now, what is next is that another scam is the misuse of journal power of attorney. People believe that GPA is equal to ownership. That is wrong. GPA does not mean any ownership over the property. A lot of flats and illegal constructions are being sold on GPAs. But the Supreme Court in Suraj Lamp and Industries Private Limited versus the state of Haryana in 2011 made it very clear. GPA sales are not valid transfers of ownership. Now, yet people still buy crores worth of land on a piece of notarized GPA. That's like buying a Mercedes just with a handwritten note. Now, what we need to understand is you have legally bought a house. You know that you are the owner of that house, but you give the house on rent to somebody. That somebody does not want to vacate the house, and uh, he becomes the person who says that I have been staying here for 12 years. I am the owner of this house now because I have got the adverse possession over this house. Now, we need to understand what tenancy disputes basically deal with is. First is eviction under the Rent Control Acts. Rent Control Acts are not generally applicable all over India, but Delhi has got a very big clientele for Delhi Rent Control Acts because all the old Delhi buildings from Chandni Chowk to Lajpat Nagar to other places are dealt with the Delhi Rent Controls Act because long back, somewhere in 1980s or 70s, agreement or a pagadi system was going on in which they said that I give you 5 lakh rupees. On basis of this 5 lakh rupees, you give me this shop on rent for another 5 years on a particular rent of 200 rupees per day or per month. And that rent is still going on. And then the Delhi Rent Control Act came into place, wherein it was said that if your rent goes beyond rupees 3,000 or 3,500, then you reach the ceiling of Delhi Rent Control Act, and after that, a revision agreement or a eviction can take place under the Delhi Rent Control Act. Now, basically, sometimes the tenants do not want to leave the property, tenants do not want to stay in the property. So, tenants say that no, we will not vacate the property. Now, another battlefield is landlords versus tenants. Rent laws in India are heavily tenant friendly, specifically in Delhi. As I said, the Daily Rent Control Act 1958 is a tenant paying 500 rupees rent since 1975 can still be protected from eviction even if the market rent is more than 5 lakhs or 50 lakhs for the time being. The typical dispute is tenant stops paying the rent, refuses to vacate, landlord has no registered agreement, only an informal handshake, courts take the tenant's word more seriously if the paperwork is weak. My advice is blunt. Always register your rent agreement. It might cost you a bit more. Rather than just a notarized rent agreement, have a registered rent agreement. And that should only come into place if your term exceeds the rent term exceeds 11 months. And a clear clause for default, eviction, and maintenance, because otherwise your 2 PHK could become somebody else's ancestral right. Now, another issue that is there, which is not being talked about much, is the NRI part. That how NRIs are suffering in the property world, what is happening to NRI properties, and this is one of the very big issues happening in states like Punjab, Haryana, wherein the Kerala also, wherein the migration is a lot, wherein most of the people have migrated to a foreign country for work, for other things. Now, NRI disputes are out of sight, out of control. The challenges is that encroachment by relatives. In NRI disputes, there are a lot of encroachments that take place by close relatives. There are NRI challenges which are done by fake documents and fraudulent sale deeds. Now, FEMA restrictions are there on agriculture lands. Now, FEMA is basically foreign exchange law, which deals with the restrictions on agricultural land. Finally, the NRI is the softest target sitting in Canada or Dubai, thinking your property in Punjab is safe because your chacha is watching it. 2 years later, you discover your cousin has mutated that land into his name and even sold it. NRIs face three major issues: encroachment by relatives, as I said, fraudulent documents created in their absence, restrictions. NRIs under FEMA Act, NRIs cannot directly buy agricultural land without RBI's permission. I represented an NRI from Australia whose ancestral home in Noida, in Ludhiana, was literally locked by tenants who refused to let him enter. The eviction case took 3 years. His mistake, no. Local power of attorney, no periodic checks. Lessons: prevention is equal to paperwork plus vigilance. Now, the last part is going to be the very important part: RERA. Why did RERA come into place? What is RERA and why do we need RERA? We have seen how family feuds, tenancy, and frauds keep the courts busy. But one of the biggest battlegrounds in the last decade has been the real estate projects. Thousands of families in Delhi, NCR, Pune, Bangalore invested life savings in flats. Builders promised delivery in 3 years, but 8 years later, still nothing but excuses. That's why government brought in a game changer, the RERA, the Real Estate Regulation and Development Act 2016. Think of RERA as a consumer code for property buyers, but with a sharper teeth. Now, basically, RERA was passed in 2016, enforced from 2017, applies to residential and commercial real estate. Mandatory registration of projects with state RERA authorities. Before RERA, builders could launch a project just with a brochure, collect crores, delay endlessly, and even change project layouts. Buyers were powerless because before RERA, when the layouts were changed, the civil suits took years to take place, and till then the property was either disposed of or never constructed. RERA flipped the script for buyers. Now every project has a certain size, must be registered, and even the project should be registered. When I say the project should be registered with the real estate authority, builders cannot advertise or sell without the registration. This gives buyers legal visibility and a forum to complain if something goes wrong. Now, basically, key rights of buyers under RERA are right to information, project plans, approvals, completion schedules. Everything has to be on the RERA website and the builder has to give it there. Now, there is a right to refund also. If the property is not being built in a proper period of time, you will get the refund. If the builder is delaying, or there are defaults in the property. Right to compensation for delays, poor construction, and false promises. You can also claim compensation. Now, there is another concept which has come in. That concept is escrow accounts. When I say escrow accounts, 70% of the funds collected from buyers should basically be used only for construction, and this is basically put in a escrow account. This escrow account is basically an account monitored by RERA. Under the RERA, if a builder promised possession in 2022 and you're still waiting in 2025, you can demand full refund with interest. Now this full refund with interest basically says that whatever amount you've paid, you will be getting that whole amount back with the interest as applicable in the present day. That could be 7%, 8%, 12%. Builders can also cannot divert the money from one project to another. पहले क्या होता था? What used to happen earlier is, for example, the builder has opened a project in Delhi. He would connect all the money from Delhi and put it in one project that was based out of, say, Bombay. And the Delhi project would RERA basically, somebody just has put a question. RERA basically means Real Estate Regulatory Act. Whenever I'm saying RERA, RERA basically is the act that we are talking about. So builders cannot divert the money. Builders, at least 70% of the funds collected must be parked in a project specific escrow account, and no more robbing. Peter to pay Paul is to be going on. Now, obligations of the builders are to register the project and provide all approvals, update progress on RERA portal quarterly, deliver as per timelines, and defect liabilities responsible for five years after possession. Now, under the RERA Act, after you've made the project, you still have liability of that project for another 5 years. Now, obligation of builders under RERA we have talking about. Uh, the builders now have homework. They must disclose everything from the land title to carpet area and update the RERA website every quarter. And here is a gem. Even after possession, if you find structural defects or quality issues within 5 years, the builder is legally bound to fix it at no cost. Though basically you have to go to the RERA forum again to basically RERA courts to basically get this thing done, but you still have that right. Now there is a landmark case of Pioneer Urban Land versus Infrastructure versus Govinda Raghavan 2019, wherein it was stated that buyers cannot be forced to take delayed possessions and refund should be there of the amount. And then there is Kolkata West International City versus Devashish Rudra 2019. It was again stated that refund and interest both have to be paid. The Supreme Court in Pioneer Urban made it clear possession if delayed, the buyer can walk away and still claim a refund with interest. Similarly, in Kolkata West International City, buyers were stuck in a project delayed for years. One case law is Pioneer Urban Land and Infrastructure versus Govindan Raghavan 2019. And the second one is Kolkata West International City versus Devashish uh, Rudra 2019. Now, basically, practical advice for buyers, which you as lawyers can give, is that always check if the project is registered on the state RERA portal. Never pay in cash. Insist on bank transfers. Read the agreement to sell carefully. Look for possession clause, penalty clause. Every RERA agreement has to have a penalty clause. That penalty clause basically deals with the time of delay that takes place. What is the amount of penalty being paid per day for the delay? And basically, also, before you book a house, check on the RERA website whether that property is registered on RERA or not. And please do not sign builder buyer agreement blindly. You need to read through it. You need to see what is the possession clause, how many years it's going to take for the possession. Now, this sums up the RERA Act at a brief. And we can just say that RERA has brought in accountability, and that was missing in real estate laws for a longer period of time. Buyers are no longer at the mercy of builders now, but the power of RERA works only if you use it. Knowledge is your first line of defense. Now, uh, that's how we're going to talk about all we're going to talk about. And I'm open for questions now. You can one by one unmute yourself and ask the questions. Questions. Okay. Rupsha, can they basically unmute themselves? I do not know how to give them the permission for that. Now, the first question is that has been given in the chat box is let's consider a situation when parents die in state. Successors are two sons. Can one son claim the whole property in court? saying he took care of the parents until they were alive. Yogesh, you can put it in the chat box only. I'll go one by one. Can this one son claim the whole property in court, saying he took care of the parents until they were alive since the other son was in different place for job? How does the court see the situation and pass a judgment? Now, basically, if parents die in state without a will, property devolves as per the Hindu Succession Act 1956, which was amended in 2005 for Hindus, and respective succession laws for other religions. Now, basically, what needs to be understood is for Hindus, class one heirs, sons, daughters, widow, mother inherit equally. So, so only if only two sons survive, they inherit in equal shares. It does not matter that one son was not staying there, one son was taking care of the parents. It makes no difference. What makes the difference is the law of the land, not the emotional aspect. As lawyers, we need to understand that until unless there is a document available which says that you were going to inherit the whole property, the courts would be very simple. Courts would be talking about a very simple logic that as per the Inheritance Act, the property is divided equally. Therefore, both the sons will get 50% share each. To the individual who asked this question, you can go through the case law of Khandap Magdam versus Hirabai Khandap Magdam 1978. It's a Supreme Court case wherein it was clearly stated that succession opens immediately on the death of the instate, and heirs get equal shares by operation of law. Contribution of caretaking is irrelevant. Now, Kalyani versus Narayan in 1980, Supreme Court again says that natural love, affection, or service rendered cannot alter statutory succession unless expressed in a valid will. Delhi High Court recently, I do not remember the name of that case. It is a 2017 case, wherein it was said that held that brother who stayed with parents and cared for them cannot claim larger share of property without a valid testament. Now, how court sees it? The second part of your question is equal right rule. That is, courts will decree partition. Both brothers get half, regardless of personal sacrifice. Sympathy is not equal to law. Judges may acknowledge caregiving son's sacrifice, but they cannot rewrite the Succession Act. Exception is there if the care giving son proves that the property was gifted to him during the parents' lifetime or there is a registered will in his favor, then he may claim exclusive ownership. What was the second question? I'll just go through the chat box once again. Hmm. The first question is if a now another question is if our opponent has sold the property and purchaser has made construction on that property. When the property is in dispute, this matter is still pending and we have temporary injunction also. What can be done in that case? See, basically, if you have a temporary injunction, in that case, you can go to the court in the contempt proceeding that this was the orders of the court and they are violating the injunction that was granted to us. That does not need a very big explanation because it is a practical aspect of lawyering which we need to understand. And now another question is, which is an interesting one, which says that if the child has foreign citizenship and his parent is Indian and died in state, in that case, that child will get the rights over the property. Child citizenship makes no difference because he still remains the first degree of relationship. Now, when I say first degree of relationship, these relationships are very clear. These relationships are mother, daughter, son, brother, depending upon the times of relationships. So basically, these relationships are very simple. If even if your son or daughter is a foreign citizen, he will still have rights over the property. Somebody has asked, what do you mean by GPA? GPA basically is a document which says Journal Power of Attorney. On that Journal Power of Attorney, you are selling one property to the another person. It needs another lecture in itself to explain it in a very depth manner, because GPAs have been used in a very bad way, and that is not a very good way to deal with it. Uh, Now, from Madras High Court, account be maintained by the builder for project. How? Sir, in this, Hari Krishnan sir, basically the concept is very simple. Uh, if there is no escrow account under the RERA Act, under Section 4.2, 1D, basically of the Real Estate Regulatory Act, a separate escrow account must be maintained for each registered project. Now, basically, if a builder has got 5 projects, he has to make 5 different escrow accounts, one for each. The builder cannot pool funds from project A into B. Now, under Maharashtra and Tamil Nadu RERA, both have clarified that law mandates one account per project and not one OMBBS account for all projects. Supreme Court have also held that RERA was designated to prevent the old practices where builder robbed Peter to pay Paul, using funds from one project to start another. So basically, the procedure is that they have to take care of a CA. The withdrawals are limited. The withdrawals are done with respect to uh, the basically they are basically told to maintain that account. A CA has to audit it. The RERA gets actual reports of that account so that not more than 70% can go there. So in simple terms, I can just state that one simple escrow account has to be there for each project. Court can't see who takes care, who didn't. Proposal on the bias. Okay. Now, singular properties are co-share over one of the co-share is different side of it. Because your question is a very technical one and can go in other ways. Matlab, that depends on how we are litigating. So, if I give an answer in the open forum, it will create a lot of confusion. So, I would request not to take this question, because when the co-sharer part comes in, we have not discussed it as of now. So maybe in the next lecture we can do that. And when we do that, we can discuss it in a very great depth, because it will create a lot of confusion for others. See, Sanjana Shaw, your question is that A has foreign citizenship and has neglected his duty. I've already answered this question. The question is very simple, that uh, you cannot basically go into the emotional side of it. Somebody who's neglected it will still have the rights over the property. Makes no difference. And basically, he does not take care of the property. Not taking care of the property does not tell you that you are not the owner of the property. If you have not taken care of the property, still you are the owner of the property. Now, Mr. Yogesh, you have asked a very practical question. We need to understand this in a very careful way. Your question is that as per Section 14.3 of the RERA Act 2016, the promoter is liable for structural defects. Your question is it mandatory for the builder developer to explicitly include the provision in the agreement for sale? The answer is yes. The answer is yes, for a very simple reason. That is Rule 8 of the RERA Moral Agreement for Sale. Now, Rule 8 of the RERA rules clearly state that uh, uh, builders are bound to use the template that is given by the RERA Act. Legally, even if the builder omits it, statutory right still applies, and courts and RERA authorities will read Section 14.3 into contract, because statutory protection overrides private agreements. Avinash, your question is still the same, that even if the boy takes care of his mom and dad, still if the parents transfer all the property in their daughter's name, can the boy see if the property is transferred by the way of a will or a gift deed which is legal and registered, the boy does not have much right over it, frankly speaking. There is a case where 712 extract is in the name of a person of a land. He has transferred his property through GPA and development agreements. Again, the power of attorney holder has transferred it to another through GPA and DAV. And what advice as a lawyer we can give to the POA holder if he has already purchased the property and came to us? Okay. Now, basically, this question is also interesting that there is a 712 given. So basically, Supreme Court in Suraj Lab and Industries versus State of Haryana said that very clearly said that GPA is not sale, do not convey ownership. So you can tell your client that it is not going to be a valid ownership. Only a registered sale deed, gift deed, or a transfer title can take place. And another safeguard is the person from whom they have bought that particular property. Uh,
Now, one more question.
sir,
Are you able to hear my voice? I'm Hari Krishna, advocate from Madras.
let me just complete this question, then I'll take the
Yes,
question.
yes, yes.
Now, basically, only a registered sale deed or a gift deed is the actual document. Now, in Maharashtra practice, the 712 is only a record of possession and revenue entry. It is not a it is not a sale deed. It does not convey ownership. Now, the GPA holder must have all the original GPAs with him. Uh, he should further say that he needs a will from the earlier party. So you can ask your question, please.
Yes, the builder has furnished one escrow account before the RERA. At the
Mhm.
same time, he has given another escrow account to the buyer to deposit the amount. What is the remedy for the buyer in such cases?
Sir, basically, they cannot have two escrow accounts.
It has
Pra-
been given in the that we challenged that two escrow accounts are there, and we have been challenged before the RERA saying that adding as an one of the director has been colluded with the builder. That
Mhm.
the petition has been dismissed on the ground of non-maintainability on account of there is no privity between the regional director as well as the buyer. So my maintainability is being argued that was being disallowed. Now, what is the remedy now?
Sir, the remedy
Several,
is basically when you're from the side of the buyer, right?
yes, buyer,
Sir, when you're from the side of the buyer, the question is very simple. Whether there was a collusion or not is not for the court to decide.
yes,
The question is very simple. When you checked the RERA authority,
yeah,
on the RERA website, the account is generally mentioned, the escrow
yes,
account.
yes,
If you have been asked to deposit money in any other account, it is a
yes.
violation. And you
That
can
has
take
been challenged, not taken into the consideration.
Sure, then you can go to the High Court for it if the RERA has not accepted it. Basically, under 421D, it is clear that there can only be one escrow account, and there have been case
Yes.
laws on it, sir. Now,
Okay.
basically, you can file.
Shall you provide in the chat box of the case laws?
Sir, I'll send you the case laws, sir.
ठीक है.
I'll send you the
Okay.
case laws. Yeah.
Okay. Thank you. Thank you.
Any other questions, please?
I want to ask that there are two brothers and they both have each testimonies from their fathers, but both are dismissed by the session court. What will High Court will do? The High Court will like sir held the decision of lower court, or they will give the different decision.
It depends on the question of law. Basically, high courts will not decide on facts. Facts are already decided in the lower court. So, if there is a question of law that has come in, then only they can go in and do something about it.
Sir, for how many years this will be this pending? Because from session court it is filed in 2009, and now their decision is came like in 2025. Now High Court, one brother held the case in High Court now in 2025. Also, how many years will take High Court will take, sir? May I know?
There is no time limit here. That is one answer that all lawyers need. How many years and how many adjournments will it take? I
Yes,
have
sir.
just
Fact
uh,
based, sir, actually both are dismissed. Both bills are dismissed. But now, what will do? Partition will take place.
yeah, see,
Definitely.
if both wills are dismissed, your practical stand as the lawyer of those parties should be to go for a partition deed. And when you go for the partition deed in the lower court, equal transaction of equal partition should take place. Rather than fighting it in high court, you should go down, file a partition suit, talk to both the parties, go down, file a partition suit, take equal shares, and get done with it. That is the practical approach to it.
So actually, one brother is divorced earlier in 1980s. So the other brother is dragging that child in the for partition for the partition of the suit. So for property, and he wants all the property.
Yeah,
He
then let the case go on in high court. You have got no rights over it till the time it is not decided. The practical aspect is a partition suit only.
thank you, sir.
Now, on the timeline that you said, how long would it be, list pendants and all, I've just written a book called Lessons from the Legal War Room, what they do not teach you in law school. In that, I've typically talked about this, that how adjournments teach you the law. So if you guys want, it will be available on Amazon from tomorrow, from Tuesday. So you can give a go to it. It is very important for first generation lawyers because I've mostly talked about the first generation lawyers only in it, and how first generation lawyers build their practice. Any other questions?
Sir, can you repeat the book name?
Lessons from the Legal War Room. What they don't teach you in law school. And those of you who've got some more questions and I've not been able to answer them right now, you can just connect with me on LinkedIn and send me your questions. I'll be more than happy to help you answer those questions.
Sir, can you share your LinkedIn ID?
It's Govind Bali, yaar. You can search Govind Bali, you will get it. Sir, can you tell about real estate law, which will evolve as a recently? I have not heard about 10-minute mein plot. I have not seen it, Diggaj Gupta. I'll have to read about it, and I do not want to comment on something that I have not read about. But if it is there, I don't think so. You can get a plot in 10 minutes. That's not possible because registry takes a lot of time. You can get food in 10 minutes, but not plot in 10 minutes. Title insurance is important. So, any other questions, please? So, thank you, everyone. This was a very enlightening session, and thank you so much.
Thank you, sir, and thank you everyone for joining. Wishing you all a pleasant and peaceful evening ahead. Thank you.